RVW.
Roe v. Wade. Okay. So, one of the big problems with anybody who wants to talk about what the Supreme Court does, you have to read the opinions. And that is hard. It is insanely time consuming because these are not easy things to read. They're written by people who we have as a country believed to be the smartest of us. That's really like the Supreme Court is like a high council in any other culture, okay? So the people who are on the Supreme Court, there's just a general belief that they're smarter than all of us. That's why they're there.
Just the name of it, Supreme.
Absolutely. So a normal Supreme Court opinion, it's above 20 pages. It's above 30 pages. They're long, okay? And there's a whole history of constitutional analysis done by this court from all the different generations, all right? So when you read Roe v. Wade, one of the things that, if you know what you're doing and you know the law, that you will see is they basically just made it up. What I mean is there wasn't any other case before this that established or came even close to establishing what Roe v. Wade did. And this context of Roe v. Wade is very similar to the context of racial issues in our country. Because there is a period of time in the 70s, 80s, early 90s that the Supreme Court is dealing with civil rights issues. Okay? And a lot of the landmark decisions were civil rights issues. And this tails into the 60s, right? I'm not saying like 70 to 79. I'm saying just this time period. So, at one period of time in the race has always been a problem for our country. I will be the first to admit it. It's always been an issue. Okay? There's our history, our founding, race was always intertwined. You know, the point where we're bringing in new states and we're trying to decide if they're going to be a slave state or not a slave state, that's what really led to the Civil War. So, at one point in time, it was the law of the land. When the Supreme Court speaks, that is the law of the land. It cannot be overturned by Florida, Texas, Oregon. That's the supreme law. So there's one time the Supreme Court said, listen, government can differentiate essentially services to different racial groups as long as the services were separate, but here's the key, but equal.
Well, how's it equal and separate?
That's what the mandate was. You ever see the old pictures of like drinking fountains that would say whites only or stuff like that?
Yes.
Okay, crazy, right? Like you would, if you ever saw that nowadays, you may get so scared and run away. You know, like that's mind blowing to think that could exist nowadays. But at one point in time, the law would basically say government could do that. They could have separate, like I said, essentially services. Like you could have separate water fountains, but they had to be equal water fountains. So you could have one that would say whites only and another one that would say essentially any other race, right? I mean, it's ridiculous to say blacks only because that's not an all-inclusive thing, right? I mean, are we talking about Hispanic individuals? How about light brown, medium brown, half brown, you know? So the government used to say that you could have separate but equal. That was based on cases from before them. There's a very important case called Plessy versus Ferguson. So then here comes Brown versus Board of Education. Here comes the big time case. And what somewhat happens in Brown versus Board of Education is the Supreme Court is not allowed to make law. They can only interpret law to be constitutional are not constitutional. The people who make law always is the legislator. That's how our system's supposed to work.
That's states.
No.
No.
So the Supreme Court is the federal high court.
Yes.
Okay. The Supreme Court is on the federal level. Okay. So cases from state courts can make their way to the Supreme Court, or cases from federal court can make their way. So the Supreme Court can hear cases from any state, any federal system. But the reality is, the Supreme Court, being a federal system, their whole job, and this is like, we could have like an hour-long podcast for how this actually went down. It was kind of like a hoodwink job. The Supreme Court wasn't really set up to do this. So the Supreme Court, what we know of it today, what they do is they review laws, either by states or by the feds, to determine if it's constitutional. That's what we can consider a layman's term of their job. They're not allowed to make law. Okay. Only the legislator, the people that we elect as lawmakers, can make law. Okay. So knowing that's a prohibition, let's go back to separate but equal and Brown versus Board of Education. So what happens is Brown versus Board of Education comes to the Supreme Court, and the Supreme Court is looking at the separate but equal standard, if you want to call it a standard. It was a law, to see if that's constitutional. Well, all the other cases before it said that was good to go, that was constitutional. What happened in Brown versus Board of Education is they used all this, the legal term would be extrinsic, but they used all this evidence that wasn't legal evidence. They were talking about, these psychiatry and there's these psychological testing where African American children were given white dolls and black dolls, and their preference was the white doll. And they were trying to figure out why, and there was just like this ingrained belief that the white doll was better than the brown doll. This is literally in the opinion from Brown versus Board of Education, where they're talking about these studies and this evidence being given to the Supreme Court. So what the Supreme Court did is they essentially struck down that standard and unified school districts, unified government services, which today is a great thing. But the reality was, at that time, they literally essentially created law. Like, their decision, how the law is supposed to work is, I'm supposed to look back on what was done before me and base my decision on that. I can't come up with something off the wall. There are legal scholars who would say, and these are not racist people, I mean, these people are themselves minorities. They would say Brown versus Board of Education may not have been a wholly legal opinion. It was the right, these people would say it was the right decision, but it may not be a wholly legal opinion. For a legal opinion to be justified, it has to stand in the world of law. It has to stand on top of all these other cases. Roe v. Wade was the same thing. See, Roe v. Wade essentially did the same thing as Brown versus Board of Education. It created its own version of law where they did this. It was almost like, I can't use that term, that's a little tongue-in-cheek. It was almost like they wanted to appease both sides. So, Roe v. Wade, they created this framework of, weird time windows. Okay, you can, abortion would be legal for this time, but it's not legal after this time. Mm-hmm. Okay? But that decision's not based on any law. That's just what they came up with. So the second case, or the case that eventually overturned Roe v. Wade, when it was going into the Supreme Court, I knew already it was going to be done. One, the Supreme Court has changed a lot. It's a lot more conservative, and it's just a different court. Okay, the courts back in the day, there were some characters as these older judges, and they just did whatever they wanted to do. They're in there for life. You know what I'm saying? No one's showing up and voting them out. So these older courts, the Court of Justice Black and these older courts, they did what they thought was right. Let's just put it that way. Okay, and these older courts, like the protection that you have in criminal cases, it doesn't come from the new court. It comes from what happened back in the 80s and the 60s and the 70s. Miranda rights comes from those time periods. You know, all these cases about being illegally searched come from those time period. Well, now it's the pendulum swung. So when it came in, I knew that they were going to overturn Roe v. Wade. And what they essentially did was they said, the lawyer in me is going to say that that was the right legal decision. People would never want to hear that, but the lawyer is going to say that that was actually the right constitutional decision, because the states historically have had the power to regulate police and health. Those are two areas that the state has been able to regulate. The feds have, almost like locusts, almost, I'm not going to say a virus, but they have embedded, like a tick, they've embedded themselves so much into these two areas that they went well beyond what the Constitution would ever allow them to do in police and in health. So what the new decision basically says is it's up to the states. Well, if you live in a state like Florida, Alabama, you know, your southern conservative states, we know what they're going to do. So that creates weird issues. I mean, are people going to be traveling? Yeah, probably.
People have found some pretty creative solutions to work their way around it. I think even somebody's even making a ship, like an offshore ship.
Yeah,
that you can
international waters.
Yeah, you can get in international waters and get it done.
Yeah, so the lawyer in me wants to say, like the unemotional lawyer wants to say, yeah, that was a legal decision. Is it going to do us good? Probably not. Probably not. I mean, you had that Freakonomics book, and one of the big things in that Freakonomics book was this whole discussion of why there was a downturn in crime. And people would say, oh, it's because we were giving all the money to the police, and, you know, we put so much of an emphasis on police. These guys who were like top rank accountants and statisticians, they said, no, it was because of Roe v. Wade. It was because the people who couldn't have children and didn't want children, the children would have been almost, I'm not going to say a nuisance, but the children would have lived a life that would have put them in more of a criminal and crime realm. Those children were gone. So if those guys are right, what's going to happen again? I mean, are we going to repeat that whole cycle again? I don't know. But so from the legal standpoint, that was actually the right decision. What happens is there's all this political gamesmanship, and there are groups out there that try to create cases to get to the Supreme Court to change law. They do this all the time. You know, they try to create these cases to get up there. For us to believe that these people in the Supreme Court are the smartest people in the world or smartest people in our country, that's not a belief that's true. These people who are on the Supreme Court, they may be bright, but they were also politically connected.
Some probably have dementia. They've been there forever, right?
Yeah. Some probably do. You know, some people were maybe not the best people. Like if we think about these societies, whatever you want to call them, tribes, and we think about, okay, the tribe has a high council or the group of elders, right? Just being smart is not the only criteria that you're going to have if you're going to be one of the group of elders, right? You're going to be smart, but you're probably going to be a super good person that we can count on making the right decision, okay? You know, you're not going to be biased towards anybody else in the tribe. You're going to make the best decision. We ain't got that. That's not what we got. We got super biased people sitting on our high council. That's the problem.
I saw Zuckerberg in court, and a guy was like, so, Mr. Zuckerberg, can you explain the internet?
Yeah.
Can you explain what Facebook is? And, like, just to hear the questions. I mean, even I got to give Zuckerberg credit for his he stayed tact on his response, but he was like,
yeah, the best was like the Google executive and the senator was like, sir, why can't my phone do this? And the guy's like, that's an iPhone. I have no idea, sir. I work for Google. He's like, it's clearly an iPhone. I don't know.